Hey guys, Marcus Melnick here with Firearm Mentor. Hope you're enjoying my YouTube channel. Don't forget to like, share, and subscribe. These little things are free to you and really help the channel. I appreciate your support. Enjoy. Thank you.
The views expressed are not those of local community broadcasting, WYML LP, or its management, volunteers, or underwriters. Greetings and welcome back to the Personal Safety Show. This is Marcus Melnick from Firearm Mentor and Stress 2 Logic, your host. And we are continuing the conversation of going through the Judge McGlynn's PICA Act Decision, and we were in the middle of talking about definitions. The next definition we're going to cover is what is defined as dangerous. Heller discusses what dangerous means in the context of firearms. The definition is inextricably linked to that of common use. The Heller Court wrote that we also recognize another important limitation on the right to keep and carry arms. Sorts of weapons protected were those in common use at the time. We think that the limitation is fairly supported by historical tradition and prohibiting the carrying of dangerous and unusual weapons. And there's a ton of resources, other cases, etc. In the conclusion to this discussion, the Supreme Court wrote, quote, "It may be objected that if the weapons are the most useful in military service, like M16 rifles, may be banned. Then the Second Amendment right is completely detached from the prefatory cause. But as we've said, the conception of the militia at the time of the Second Amendment's ratification was the body of all citizens capable of military service who would bring the sorts of lawful weapons they possessed at home to militia duty. It may be true that today a militia could be as effective as militias in the 18th century, but they would require more sophisticated arms that are highly unusual in society at large. Indeed, it may be true that no amount of small arms could be useful against modern-day bombers and tanks, but the fact that modern developments have limited the degree of fit between the prefatory clause and the protected right cannot change our interpretation of the right." End quote. So what does the word unusual mean? Regarding the definition of unusual, the dictionary defines the term as uncommon or rare. And that's according to the Merriam-Webster dictionary. Defining unusual in the context of the Second Amendment is not as easy as it is to determine which arms are usually used in self-defense. Historically, usual weapons for confrontation included bladed weapons like knives, spears and swords, blunt weapons like clubs, and ranged weapons like bows, bullet-firing weapons like pistols and rifles, and projectile-firing weapons like crossbows, some rifles and shotguns. Today, due to advantages in technology, our self-defense weapons include electrically charged tasers and canisters spraying mace and pepper spray. There are two qualities or characteristics that make an arm unusual. The first quality is the atypical way in which an arm neutralizes an opponent. The second is an arm that harms an opponent in a way that is repulsive. This is odd to contemplate when the focus of the purposeful use of lethal weapons. Nonetheless, included within this category would be weapons or arms that use chemicals like acids to inflict horrible pain and leave permanent scars, arms that eject blister agents, and arms that use lasers to blind an adversary. Additionally, poisons, including radioactive compounds, are unusual. And that's from the Bianchi case. The use of a biological agent, in addition to being dangerous, is also atypical when compared to types of arms used for self-defense. Unusual, as related to the Second Amendment, also has an element of cruel and unusual in accordance with the Eighth Amendment. We've banned weapons for use in war because even in a war setting, they are cruel, brutal, and indiscriminate, also inhumane. Thus, their use in war is prohibited. The 1980 Convention on Certain Conventional Weapons banned poison gases, non-detachable fragments. A non-detachable fragment cannot be detected in the human body via X-ray. landmines, incendiary weapons, poisoned bullets, cluster bombs, and biological weapons. In the context of the Second Amendment, when it comes to firearms, technical advances or improvements are expected and are not unusual. As an example, prior to 1950, almost all rifle stocks were wooden. But with advances in composite materials, now many are made of synthetics. When applied to a handheld or shoulder-mounted firearms, unusual means those weapons that can launch or emit lethal or seriously harmful explosives, chemical or biological agents, poisons, blister agents, oral weapons, or directed energy weapons like lasers. Handheld or shoulder-mounted weapons that deploy high thermal energy would also fall under the category of unusual for Second Amendment purposes. In looking at the items banned by PICA, the only items that fall under the unusual category would be grenade launchers and belt-fed munitions. Grenades are included in this category because no one uses them for self-defense. Belt-fed munitions are included because civilians just don't purchase firearms in which cartridges are fed through a belt rather than housed in a cylinder or magazine. Therefore, considering the above, unusual is defined as an arm deploying an atypical method to neutralize an opponent in confrontation, or that deploys a neutralizing agent that is caustic, incendiary, noxious, poisonous, or radioactive. Unusual would also include those weapons that are not designed for successful self-defense in neutralizing an opponent, but rather are primarily deployed to inflict cruel, brutal, or inhumane suffering to another person. The definition of common use is very interesting. Having developed workable definitions for bearable, dangerous, and unusual, now we're talking about common use. The Supreme Court said that it was fairly supported by the historical tradition of prohibiting the carrying of dangerous and unusual weapons, that the Second Amendment protects the possession and use of weapons that are in common use all the time. The brief asserts that there's at least 20 million AR-15s and similar rifles that are owned by about 16 million citizens. That's a lot of guns. The plaintiffs also assert that at least 150 million magazines with a capacity greater than 10 rounds have been bought for private use. The state criticizes these numbers for being biased, says it's on an unpublished, non-peer-reviewed paper recounting on the online survey that does not disclose its funding or measurement tools. So, Cook County differs from a different perspective, noting that all the firearms in the country, only 5.3% are assault weapons, and that percentage includes those held by law enforcement agencies. One is reminded of Mark Twain's remark, there are three kinds of lies: lies, damn lies, and statistics. For the reasons set forth in the Friedman case, which we didn't discuss here, but you can look up the Friedman versus Highland Park case, the court declines to base their assessment on the constitutionality of these laws on numbers alone. Such an analysis would have anomalous consequences. The problem with that approach can be seen in the case of the AR-15. In 1994, the federal assault weapons ban made civilian possession of the AR-15 and other assault weapons unlawful, and few civilians at that time owned AR-15s. But in 2004, after the legislation expired, these weapons began to occupy a more significant share of the market. Indeed, most of the AR-15s now in use were manufactured in the past 2 decades. Thus, if we just looked at the numbers alone, the federal ban would have been constitutional before 2004, but unconstitutional thereafter. This conclusion is essential to the plaintiff's position, yet it lacks both textual and historical perspective. At the time of the founding of the country, this was an inflection point in American history. Lofty ideas became written laws. It changed the arc of America's destiny. The supreme law of the land no longer just spoke of separation of power, who can make treaties and mint coins, but now there's a much more profound repertoire with the Bill of Rights. Consider the genius of what was enshrined as a guarantee to each individual citizen. Under the First Amendment, citizens have free exercise of religion, freedom of speech, freedom of the press, the right to peacefully assemble, and the right to petition the government for a redress of grievances. The Second Amendment establishes the right to keep and bear arms. The Third Amendment, no quartering of soldiers in peacetime without the consent of the owner. And the Fourth Amendment protects us to be secure in our homes, our papers, and our effects against an unreasonable search and seizure, and no warrant shall issue but upon probable cause supported by oath and affirmation, and particularly describing the place to be searched and the person or things to be seized. Under the Fifth Amendment, no one shall held to be answer to an infamous crime unless upon indictment by a grand jury. There's no double jeopardy, which means if you are tried in a case and the state loses, they can't retry you. They cannot be compelled to be a witness against oneself. That's saying I plead the Fifth. They cannot be deprived of life, liberty, or property without due process of the law. And no private property may be taken for public use without just compensation. Under the Sixth Amendment, a right to a speedy criminal trial, a right to a public criminal trial. A person must be tried in a state and district where the alleged crime occurred, and to be informed of the nature and cause of the accusation. The Sixth Amendment also protects us to be confronted with witnesses against them, which means they have to face the witnesses, to have a compulsory process for obtaining witnesses in their favor, that's subpoenaing them, and to have assistance of counsel for his defense. Under the Seventh Amendment, a right to a jury trial in suits for common law. And under the Eighth Amendment, no person shall be required to pay excessive bail, excessive fine, or suffer the infliction of cruel and unusual punishments. Judge McGlynn concludes by talking about, with the utmost respect for the Seventh Circuit's determination, this court is concerned that the statutes described do not adequately evince a history and tradition of the regulation of specific semi-automatic rifles, shotguns, and attachments. The court also emphasizes that the rights of Illinois citizens to keep and bear arms in the 21st century are not vexed, at least by the Statute of Northampton and similar laws passed centuries before the foundation of our nation. After an exhaustive review of the statutes and arguments provided by the government, the court holds that the nation's history and tradition of firearms regulation does not support a statute as far-reaching as PICA. Put another way, the government's arguments do not satisfactorily answer the how and the why questions required by Bruin. Much of the statute it cites were prohibitions on concealed carry or on discharging weapons, not the outright prohibition of such weapons entirely. The crux of Judge McGlynn's opinion states, considering the four factors discussed, the plaintiffs, meaning the regular people who sued the state, have successfully proven the merits of their case. Clearly, remedies at law are insufficient to remedy an injury of constitutional magnitude, such as PICA's infringement on Illinois citizens' time-honored right to bear arms guaranteed by the Second Amendment. Considering the balance of hardships, it is clear that a remedy in equity is warranted. The constitutional inquiry here demands action from this court in accordance with the Second Amendment's quote, unqualified command, which is from Bruin. While the plaintiff's vagueness concerns about the PICA text have been previously addressed, the court is deeply concerned about arbitrary enforcement. Various sheriff's departments in Illinois have expressly indicated that they will decline to enforce PICA in their counties. See Sarah Schulte, New Gun Law, over 24 sheriffs refuse to enforce Illinois assault weapons ban, from ABC 7 Chicago on January 12, 2023. That link is actually in the decision. So if you wanted to look that up, you can certainly do that. Indeed, the McHenry County Sheriff's Department, one of the defendants in Barnett, filed a response to the motion for preliminary injunction expressing that they believe PICA is unconstitutional. Therefore, it stands to reason that PICA can and will be enforced arbitrarily. The data also indicate that property crimes are increasing across the country. According to the FBI, violent crime decreases to pre-pandemic levels, but property crime is on the rise. And that's from U.S. News and World Report from October 16, 2023. Judge McGlynn talks about what is particularly disturbing is that the prohibition of weapons that are commonly owned and used by citizens are now banned, depriving citizens of a principal means to defend themselves and their property in situations where a handgun or a shotgun alone would not be the preferred arm of the citizen. Therefore, the court must take action as justice demands. PICA is an unconstitutional affront to the Second Amendment and must be enjoined. The government may not deprive law-abiding citizens of their guaranteed right to self-defense as a means of offense. The court will stay enforcement of the permanent injunction for a period of 30 days from the date of this order, which was November 7th. Concluding observations state, sadly, there are those who seek to usher in a sort of post-Constitution era where citizens' individual rights are not only as important as they are convenient to a ruling class. Seeking ancient laws that may partner well with a present-day infringement on a right proclaimed in the Bill of Rights without reading it in conjunction with the aforementioned history is nonsense. The Statute of Northampton cannot in the least be used to vex the rights of Illinois citizens in the 21st century to keep and bear arms. The oft-quoted phrase that no right is absolute does not mean that fundamental rights precariously subsist subject to the whims, caprice, or appetite of the government officials or judges. In conclusion, for the reasons set forth above, the government's motion for partial summary judgment on the Langley's plaintiffs' counts 4 and 6 is granted. Most importantly, considering all of the evidence presented, the court holds that the provisions of PICA criminalizing the knowing possession of specific semi-automatic rifles, shotguns, magazines, and attachments are unconstitutional under the Second Amendment to the U.S. Constitution as applied to the states through the 14th Amendment. Therefore, the plaintiff's request for permanent injunction is granted. The state of Illinois is hereby enjoined from the enforcement of the PICA criminal penalties in accordance with 720 IL compiled statute 5/24, etc., bump stocks and assault weapons. Also, large capacity magazines against all citizens effective immediately. As the prohibition of firearms is unconstitutional, so is the registration scheme for assault weapons, attachments, and large capacity magazines. Therefore, the state of Illinois is enjoined from enforcing the firearm registration requirements and penalties associated with entering false information on the endorsement affidavit for non-exempt weapons, magazines, and attachments previously required to be registered in accordance with the PICA Act. This permanent injunction is stayed for 30 days. The clerk of the court is directed to enter judgment in favor of the plaintiffs. It is so ordered, dated November 8th, 2024, signed by Stephen P. McGlynn, U.S. District Judge. There you have it, folks. I am hopeful, as I'm sure a lot of people are, that we will be able to make our purchases the second week of December and that this is actually permanently thrown down. Now, people, don't expect the legislature to back down. They're going to create another law and another law and another law because that's what they do. And I've always said, I think if a legislature or legislator favors a law that is later proven unconstitutional, this is an opinion, they shouldn't be able to run for office. Period. The end. We're going to take a brief break because I just went through a ton of stuff and I need to get a drink. So I'll be right back. Stay tuned. I want my listeners to know that this is my dream, teaching people about safety. If it weren't for you, if it weren't for my listeners, I couldn't live my dream. So on behalf of my family and myself, I want to thank each and every one of you for allowing me to live my dream. And I also want to continue to live my dream, and I'm excited to continue to spread the word of safety. Recently, I began a new service as a conference keynote speaker. So, if anyone would like for me to speak at future events, or if anyone knows of an introduction or would like to discuss how we can work with one another, I'd love to do just that. The keynote speaking website is www.stress2logic.com. That is STRES2logic.com. If you're aware of any conference speaking engagements where you'd like to have me speak, I'd love an introduction. You can always share my electronic business card, which is Marcus Melnick, MarcusMelnick.com. Now, back to the show. Well, folks, I hope you found that enjoyable and educational. I want to share an experience I had earlier in the week with a student who's on the petite size-wise, and her hands were very, very, very small, almost childlike. And as I was working through, she is interested in getting a new firearm. I'm racking my brain, not racking the gun, racking my brain, that I got to find something that would work for her. And this is the list that I came up with. A Walther PD 380, Glock 42, 43, or 43X, a Smith and Wesson Shield Plus or Shield EZ, Springfield Hellcat, SIG 365 or 238, or the Smith and Wesson Bodyguard 2.0. Now, Smith and Wesson just released this. It's new for 2024, and I've actually been eyeballing it. It's an interesting little gun. It looks like an M&P, the larger ones, but it's a small pocket rocket in 380. Originally, their Bodyguard pistol came out in 2010. There was a little bit of a big oomph and a push, and then it kind of died out. I didn't really care for them. I thought that the grip was too short for me. And 11 years ago, when I first started doing range qualifications, we had a student, and she had one. She put in her magazine, she racked the slide, and nothing happened because she didn't move her pinky and the bottom of her palm out of the way so the magazine could seat properly. I've also experienced, or I've been told, I've seen them jam a lot. Now, the 2.0, wow, that's a little bit of a different design. Smith and Wesson appears to have addressed everything that has been less than perfect with the previous generation, whether it's perceptual or real. So Smith and Wesson is probably going to have a hard time keeping this one on the shelves. But before the details of the pistol, it's smaller than it looks in photos. It's surprisingly small. In photos, it kind of looks like an M&P, but because of the proportions, a Shield is significantly larger than a Bodyguard 2.0, and the Bodyguard's competition, which is the Glock 42 at $479, the Bodyguard is smaller in every dimension and lighter while holding 40% more ammo. It's a good thing. Backup 380 pistols should be small. If you're the least bit interested, I urge you to head down to the local store and get one in your hand. Another competitor that may be a little bit more on the plane is the Ruger LCP Max. That has a single action trigger as opposed to a striker fire trigger, and it's also a pocket gun. This new Bodyguard is polymer framed. It's a striker fired pistol, and it comes with two mags, a 10-rounder and a 12-rounder with a grip extension. With the flush mag, it weighs 11.4 ounces, according to the author who weighed it. It's 4.1 inches tall and 5.6 inches long, with a 23/4-inch barrel. Pistol's also very thin. At its thickest point, which is the mag release, it measures 1 inch thick exactly, but the grip is only 0.89 inches thick, and the slide is 3/4 of an inch thick. Currently, there's two models. The only difference is whether you prefer one with a safety or not. Some people love safeties, some people don't. That's an individual decision. I prefer not safeties, except if it's on a single action firearm, that's a preference. The Bodyguard has almost the same proportions as a full-size M&P. It's the same duty-grade features and controls, even though it doesn't really have the words M&P, quote, in its name. The front sight is a wide day-night from True Glow. It's a high-visibility orange ring and a tritium insert, and you can see it regardless of lighting conditions. The rear sight is plain black and serrated with a healthy U-shaped notch. The notch puts a lot of daylight around that big front sight when aiming. Interestingly, the front of the rear sight has a vertical segment so you can rack the slide one-handed on a hard surface if needed. It's not optics ready, at least not these initial models. Due to the thin nature of the slide, it's probably not going to happen until someone comes out with a smaller optic. And some people love optics on carry guns, but deep concealment means it's going to snag on your pocket if you try to get it out. So it's kind of silly. It's a short-range firearm. It looks really cool. The slide and the barrel are stainless with an Armor Night finish, which is Smith and Wesson's version of black nitride. The slide has a matte quality finish, which helps it make it grippy, and its generous directionally angled slide serrations also help it. As Smith & Wesson describes in its marketing materials, the slide is aggressive without being sharp, and a sizable cutout at the rear of the barrel hood serves as a loaded chamber indicator. There's a few things that fascinate people. One is a standard tilt barrel design, just like the other M&Ps, and most 380s are a straight blowback operating system. Blowback guns are simpler, and all you need for a 380. So head down to your local gun store, see how it fits in your hand. It is kind of grippy, meaning it's a little bit sandpapery, but it's definitely worth a look. Stay tuned for another episode next week, and I hope everyone has a safe week. Thank you. We have monthly concealed carry license CCL classes in the northwest suburbs of Chicago. Dates can be seen at firearmmentor.com/classes. If you have a question, we can be reached at www.firearmmentorcard.com. That is our electronic business card, has all of our contact information and links in it. It's the easiest way to get a hold of us. Until next time, stay safe out there, and I'll see you at the shooting range. This is Marcus Melnick from Firearm Mentor signing off. The views expressed are not those of local community broadcasting, WYML LP, or its management, volunteers, or underwriters.